Well, it's good news for people that like bad news, because as bad as your holiday season might have been, it wasn't nearly as bad as Rudy Giuliani's. Federal jury has ordered Rudy Giuliani to pay over $148 million to Georgia election workers Ruby Freeman and Shay Moss for falsely claiming they committed ballot fraud in the 2020 presidential election. To some people, Giuliani's fall from grace has been a surprise. But it wasn't a shock to Rudy himself, though. In 2019, Giuliani was asked if, quote, saying things for Trump, not always being truthful about it, do you ever worry that this will be your legacy? And his answer was yes. Well, Rudy, don't get ahead of yourself, because you can explain it to the bankruptcy court first, because defamation claims are not always dischargeable in bankruptcy, and he's about to spend the rest of his life paying Moss and Freeman. So today we're going to talk about the defamation case against Giuliani, his chances of getting the award reduced on appeal, and figure out how many cameos he has to sell to make $148 million.
Hi, Devin. I'm calling to congratulate you on quite an accomplishment.
And how much he's actually going to have to pay. Now, as almost everyone knows by now, Joe Biden legitimately beat Donald Trump in Georgia, ensuring that he received enough electoral votes to replace Trump as president. But MAGA world refused to believe that Biden beat Trump fair and square, and Trump and his allies quickly seized on two individual election staffers, Ruby Freeman and Shay Moss, as the central villains in this plot against America. Moss and Freeman are mother and daughter board of election workers from Fulton County, Georgia, who helped count the votes on election day. And as they alleged, on December 3rd, 2020, the Trump campaign published an edited video from a grainy security camera that showed unidentified persons, including individuals later identified as Miss Freeman and Miss Moss, counting ballots. Now, this video became the basis of a conspiracy theory that Freeman and Moss were counting suitcases full of fake ballots and uploading more fake ballots from thumb drives. Trump named the women in his infamous call with Brad Raffensperger. And Trump's allies also spread these false claims, but Rudy Giuliani was the most visible. Giuliani appeared on OAN day after day claiming that Moss and Freeman were criminals.
How about the videotape that I have where they're shoving the thing into the machine 3 and 4 times so that it can be recounted by the same two women that earlier in the day were passing around hard drives or flash drives that supposedly can't be used in Dominion machines, but can.
Right.
And the complaint said that OAN, quote, leveraged Giuliani's unsupported factual assertions and almost immediately published them to millions of its viewers and readers, subsequently adding Miss Freeman's and Miss Moss's names and leveling additional accusations of criminal fraud against them. And it didn't take long for Georgia election officials to debunk Giuliani's assertions about Freeman and Moss. Quote, within 24 hours of Giuliani and the Trump campaign's original publication of these lies, Georgia election officials explained that the video contained, quote, no suitcases, no illegal ballot counting, no election fraud. A full hand recount of Georgia's election results had already confirmed the election results, and by December 7th, so would the recount requested by the Trump campaign. Through December and January, Georgia's Republican election officials continued to explain to the public again and again that thorough reviews had disproven defendants' false claims and proven that no illegal ballot counting had occurred. Giuliani and the Trump campaign were not deterred, though. Giuliani subsequently testified at a hearing before the Georgia House of Representatives Government Affairs Committee, where he played the video and falsely claimed that it showed, quote, voter fraud right in front of people's eyes and was the tip of the iceberg. Giuliani also discussed Freeman and Moss on his podcast and Twitter account. Giuliani's media appearances and the tweets resulted in 33 million online impressions of Freeman alone. Trump's fans, who were convinced Freeman and Moss were the ones standing in the way of his re-election, started showing up at their homes. On January 6, 2021, a crowd on foot and in vehicles surrounded Freeman's house. Her online boutique was flooded with threatening messages, including several that mentioned lynching shortly after Giuliani tweeted the video of her. She said, quote, I took it as though they were going to hang me with their ropes on my street. I was scared. I didn't know if they were coming to kill me. The complaint stated that Freeman was forced to shutter her online business when social media became impossible to navigate. Eventually, Freeman, at the recommendation of the FBI, fled her home and did not return for 2 months. Moss testified before the January 6th committee about how something as innocuous as passing her mother a ginger mint had now been portrayed as her stealing a presidential election.
In one of the videos we just watched, Mr. Giuliani accused you and your mother of passing some sort of USB drive to each other. What was your mom actually handing you on that video?
A ginger mint.
In other testimony, Freeman described how unsafe Giuliani and Trump's actions made her feel in her own community.
I stayed away from my home for approximately 2 months. It was horrible. I felt homeless. I felt, I can't believe this person has caused this much damage to me and my family. To have to leave my home, that I've lived there for 21 years.
Moss and Freeman said they received numerous death threats. Quote, on at least 2 occasions, strangers showed up at her grandmother's home and attempted to push into the house in order to make a citizen's arrest. On these occasions, Miss Moss's grandmother, who was in her mid-70s, called her in panic, confused and scared for her safety. The Fulton County Board of Elections, quote, general email address would forward incoming emails to Ms. Moss and many of her colleagues, filling her workplace with harassing messages. So Moss and Freeman sued Giuliani, OAN, and the other defendants for defamation and intentional infliction of emotional distress. In most civil defamation trials, jurors first decide whether these statements made were defamatory. And if they were defamatory, then the jury then decides whether the person who made them intentionally inflicted emotional distress and whether they suffered damages. However, Giuliani chose the same defense strategy as Alex Jones when he was sued by the families of the children killed at the Sandy Hook Elementary School, refusing to participate in the discovery process in good faith. Judge Beryl Howell entered a default judgment against Giuliani before the trial began. So the jury was told that Giuliani defamed Freeman and Moss and that the two women were also entitled to punitive damages. The trial was simply to determine how much Giuliani would have to pay. But that raises the question, why wouldn't Giuliani participate in the discovery process in good faith? Well, there are probably many reasons, but some of the most important ones are Jack Smith and Donald Trump. Giuliani is already facing criminal charges for his participation in the scheme to submit fake electoral votes in Georgia. He's also described as an uncharged co-conspirator number 1 in Trump's indictment on federal charges in Washington for obstruction of the 2020 election. So if Giuliani meaningfully participated in discovery, it's likely that Smith would get to see everything that Giuliani produced in the civil discovery process, which could lead to Giuliani being indicted in DC. And on top of it, this kind of discovery can get extremely expensive as well. Giuliani famously is going through money problems as well, so much so that he asked for Trump's help. His ex-lawyer is suing him for $1.3 million in unpaid legal fees, and during an August hearing in another case, his lawyer said Rudy was close to broke and unable to pay a number of bills. Apparently making cameo videos for LegalEagle doesn't generate enough income to pay these huge legal bills.
You're an ace attorney and a legal eagle, and I admire really good attorneys.
Now, a Trump-affiliated PAC gave Giuliani $350,000, and Trump held a $100,000 a head fundraiser for Giuliani last fall, but it's not clear how much of an impact that has made, given all of these legal fees. Now, this whole case has been marked by a couple of Giuliani's really dumb legal strategies. At one point, in an effort to stop the judge from ruling on the discovery issues, Giuliani filed a stipulation purporting to admit liability. A stipulation is a binding agreement between opposing parties on a relevant issue in the case. Giuliani's stipulation said he, quote, does not contest that his statements were false and carry meaning that is defamatory per se. He was also willing to offer that his statements met the factual elements of liability for Moss and Freeman's claims that his attacks amounted to intentional infliction of emotional distress and civil conspiracy. The idea being that Rudy would offer these stipulations in exchange for not actually having to produce discovery that would have led to those factual conclusions. But Rudy and Sibley seemed to bungle the stipulation because it included a disclaimer saying that he reserved the right to claim that his statements weren't defamatory after all on appeal. Sibley said that the stipulation wasn't an admission of liability, it was a decision not to contest the lawsuit. But as Judge Howell concluded, quote, Giuliani's stipulations hold more holes than Swiss cheese, with his latest stipulation expressly reserving his arguments that these statements complained of are protected and non-actionable opinion for purposes of appeal. She wrote that just as taking shortcuts to win an election carries risks, even potential criminal liability, bypassing the discovery process carries serious sanctions, no matter what reservations a non-compliant party may try artificially to preserve for appeal. Now, obviously, Rudy really would have benefited from a good lawyer during this whole process. But if you want a great lawyer, my firm, the Eagle team, can help. If you've suffered a data breach, especially if you've got a data breach letter, were involved in a car crash, or dealt with sexual harassment, we can represent you or help find you the right attorney. It's important to talk to a lawyer right away so you can get the best representation and find out what your options are. So just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is down below. But it's also worth taking a quick look at Judge Howell's scathing opinion about Giuliani's conduct in this case. When a party is on notice that there will be litigation, they are required to preserve potentially relevant evidence, including electronically stored information, which is known as ESI. If a party fails to take steps to preserve ESI, quote, and it cannot be restored or replaced through additional discovery, a court may order measures no greater than necessary to cure the prejudice. This misconduct, also known as spoliation, is the destruction or material alteration of evidence or the failure to preserve properly for another's use as evidence in pending or reasonably foreseeable litigation. Judges and lawyers take this kind of thing very seriously because if evidence is destroyed, then you have a much harder time making your case. And believe me, we lawyers really enjoy going through your ESI, including your emails, because that's where all the juicy information is. So destruction of evidence is serious. So upon a finding that the party acted with the intent to deprive another party of the information's use in the litigation, a court is empowered to impose severe sanctions, including presuming that the lost information was unfavorable to the party, instructing the jury that it may or must presume the information was unfavorable to the party, or dismissing the action or entering a default judgment. The judge here found that Giuliani should have preserved ESI as early as January of 2021, but did not take reasonable steps to preserve it and didn't even turn off the auto delete until later that same year. Judge Howell pointed out that Giuliani isn't some regular guy who's never seen the inside of a courtroom and doesn't know anything about preserving evidence. Quote, "The fact that Giuliani is a sophisticated litigant with a self-professed 50 years of experience in litigation, including serving as a U.S. attorney for the Southern District of New York, only underscores his lackluster preservation efforts." Giuliani argued that the FBI was responsible for destroying the ESI. The FBI confiscated Giuliani's devices because he's facing criminal charges. Quote, "When the devices were finally returned to Giuliani, the Costello Declaration repeats Giuliani's assertion that all the devices had been wiped clean by the vendor for the government. But without any verification of this fact by any expert forensic examiner or even a professional information technology professional." And Judge Howell had reason to believe Giuliani acted intentionally. Plaintiffs obtained responsive documents produced by third parties, including Giuliani's assistants, which should have been turned over by Giuliani himself. In a footnote, the judge said, quote, "Indeed, the House Select Committee released a December 13th, 2020 email from Giuliani to Epstein, in which Giuliani approved a draft statement from the Trump legal team that stated, quote, Georgia has video evidence of 30,000 illegal ballots cast after the observers were removed, referencing Giuliani's false claim about the plaintiffs. Yet Giuliani never produced that email to plaintiffs, nor, as far as plaintiffs' counsel can discern, did he ever claim privilege over it. And according to Judge Howell, the ESI has now been irretrievably lost. So why did that justify a default judgment? Well, because Giuliani's ESI was relevant to all of the plaintiff's claims. Giuliani argued that Ruby Freeman is a limited purpose public figure, which means she would have had to show that Giuliani's statements about her were made with actual malice. That means Freeman would have to prove that Giuliani published false statements concerning her with knowledge that it was false or with reckless disregard about whether it was false or not. Quote, "Without access to circumstantial evidence of Giuliani's state of mind in the form of his messages and email communications with associates or other contemporaneous records of his thoughts when he made the false statements against Freeman, plaintiffs are severely hampered in being able to refute Giuliani's defense that he made his statements about Freeman merely negligently." The same was true of their other claims, intentional infliction of emotional distress and civil conspiracy. Judge Howell entered judgment against Giuliani as a discovery sanction and set a trial to determine damages. However, even after his discovery abuse, Judge Howell gave Rudy one last chance to avoid total disaster. Quote, "As this case now heads to trial to determine any damages due to plaintiff's claims, Giuliani will be given a final opportunity to comply with discovery relevant to the determination of damages, both compensatory and punitive, or face imposition of additional discovery-related sanctions under Rule 37b-2 in the form of adverse instructions and exclusion of evidence at trial." Now, Giuliani could have mitigated the amount of the damages owed to him if he produced evidence about his personal net worth and paid plaintiffs' legal fees. But Giuliani chose not to, and by the time the case went to trial on damages, he had less ability to challenge the plaintiff's estimation of their damages. So what is Giuliani's net worth, and how much money can Rudy actually pay the two women he defamed? Well, we don't know. He didn't comply with Judge Howell's order to turn over information on his finances. During the trial, Giuliani's lawyer argued that he didn't have any money, but without admissible evidence to back that up, his arguments fell flat. The plaintiff's attorney, Michael Gottlieb, told jurors that Giuliani is still a celebrity who makes frequent media appearances and has a deal with right-wing network Newsmax. Quote, "Giuliani profited from these lies. We don't know how much." So Gottlieb asked the jury to punish Giuliani with punitive damages. The plaintiff's expert witness, Ashley Humphreys of Northwestern University, estimated that they were entitled to $18 to $48 million to compensate for the loss of their reputations. That was the amount that she believed it would take to restore their images through a social media campaign. Humphreys cited the huge interest in online misinformation about them after Giuliani and Trump publicly accused them of sabotage. Gottlieb said that if Moss had been able to stay in her job as an election worker, which paid $39,000 a year, would have made about $800,000 over her lifetime. Now, interestingly, Giuliani initially said he would testify at trial, but his lawyer, Joseph Sibley, changed his mind at the last minute, saying, unbelievably but accurately, quote, "These two women have been through enough." And Sibley argued for compassion, admitting that Giuliani did an injustice to the plaintiffs, but that he was just a 79-year-old man who believes in conspiracy theories. Sibley repeatedly compared his client to a flat earther. And finally, he argued during his closing that the jury should remember the time that Giuliani saved the city after 9/11. Sibley said his client was a unifying figure, not the broken old conspiracy theorist he is today. Quote, "This is a man who did great things. If he hasn't been so great lately, I want you to judge him by his entire character of who he is." The jury seemingly did so and returned a verdict of $148 million. Freeman was awarded $16.1 million for the damage done to her reputation. Moss was awarded $16.9 million for the damage to her reputation. Each woman was awarded $20 million for the emotional distress caused by Giuliani's defamation. And finally, Giuliani was fined $75 million in punitive damages for defaming them. So will he have to pay all of that $148 million? Well, probably not, and certainly not anytime soon. He's probably going to appeal the verdict, but even an appeal won't provide him with total help. There are some limitations on how big punitive damages awards can be, and they can't be too big of a multiple of the actual damages, probably not more than a single-digit multiplier. They also can't be too large a percentage of the defendant's net worth. In some cases, courts have said the punitives can't be more than 10% of their net worth, but even here, this argument runs into a major obstacle, Giuliani's discovery abuse. Now, if a party refuses discovery into their own net worth and abuses the discovery process, they aren't allowed to appeal on the basis of the award being excessive in light of their net worth. And even if Giuliani got a good result from the Court of Appeals, such as completely wiping out all the punitive damages, he would still owe tens of millions of dollars. Now, generally a party who owes damages has 30 days before the judgment is enforced. However, Freeman and Moss filed a motion asking for the 30-day automatic stay to be dissolved because of the risk that Giuliani would use that time to conceal his assets. Judge Howell agreed and issued an order finding that Giuliani must immediately pay the $148 million. Judge Howell concluded that, quote, "Giuliani has proven himself to be an unwilling and uncooperative litigant who blew off the court's discovery deadlines, didn't disclose his financial information, and ignored the court's orders to pay attorney's fees." Judge Howell said, quote, "As plaintiffs submit and as Giuliani does not contest, Giuliani has numerous and mounting debts, including his own attorneys and other litigants seeking to reduce their claims to judgment." Now, despite these debts, Judge Howell questioned whether Giuliani is really skint. Quote, "Nowhere in opposition does Giuliani promise not to hide assets from plaintiffs, nor does he contend, let alone demonstrate with documentary or other proof, that he would be unable to satisfy the judgment in whole or in part." She says he owns property in Florida and New York and appears to have accounts at several financial institutions. The order concludes that Giuliani is unlikely to succeed on appeal. And in yet more bad news for Rudy, the judge said she'll probably require him to post an appeal bond equivalent to the judgment if he wants to appeal. If he has to post a bond, it would be harder for him to draw down his assets. But of course, later that same day, surprise, surprise, Giuliani filed for Chapter 11 bankruptcy. According to the filing, Giuliani's net worth is between 1 and 10 million, but he owes around, give or take, $151,787,859.90. Now that's including the Moss-Freeman judgment, $3.5 million to law firms, and $1 million in taxes. He anticipates owing money to Noel Dumfrey, who sued him for sexual harassment, Dominion, who sued him for defamation, and Hunter Biden, who sued Rudy for hacking his laptop. And he also owes an unstated amount to his own company, Giuliani Partners, and $30,000 for an unpaid phone bill. So naturally, this all leads to a question of bankruptcy. Now, a person can discharge some types of debts in bankruptcy, but intentional torts are often treated differently. Intentional torts involve actions where the wrongdoer intended to cause harm, such as battery or sometimes defamation. Section 523A of the United States Bankruptcy Code outlines the kinds of debts that are generally not dischargeable. Quote, "A bankruptcy discharge releases the debtor from personal liability for certain specified types of debts. In other words, the debtor is no longer legally required to pay any debts that are discharged. Debts arising from willful and malicious injury to another person for their property are among the debts that may be non-dischargeable. For debt to be excluded from bankruptcy discharge, the debtor must prove that his actions weren't willful and malicious. But Giuliani would have a really hard time proving that, especially since he's now continued his defamatory attacks on Freeman and Moss. Yeah, Giuliani is now following the Trump blueprint of losing a defamation case by repeating the false claims and then being sued again by the same plaintiffs. Giuliani made several comments after the trial, including appearances on Newsmax and Steve Bannon's podcast, where he trashed the DC trial court and repeated allegations about plaintiffs. And inexplicably, he even went after Moss and Freeman on the courthouse steps after the verdict.
That what I said was true, and that whatever happened to them, which is, it's unfortunate if other people overreacted, but everything I said about them is true.
So I guess I already need to make another video about his future defamation claims. In fact, there's so many claims that I can't release everything on YouTube. But thanks to the power of today's sponsor, Nebula, you can watch all of my videos ad-free and early. Now, I'm not only on Nebula, but I'm also a co-owner, because Nebula is a streaming platform built for creators by creators. And for the holidays, they are doing something completely wild. Nebula is offering until the end of the month a lifetime membership. Instead of a subscription, it's a one-time payment that will get you everything Nebula offers forever. And for the first time ever, Nebula is also allowing people to buy gift cards so you can gift a lifetime subscription of Nebula to a friend or loved one. And I know tens of thousands of you signed up for Nebula using the CuriosityStream bundle, but unfortunately that is ending. CuriosityStream has informed us, and even included in their latest SEC filing, that they don't intend to pay us bundle revenue through 2024. This means that my creator friends and I won't get any money for bundle subscribers. So the bundle is breaking, and you're not going to be able to have access to Nebula anymore after 2024 if you signed up with CuriosityStream. Maybe I'll make a video about that soon. But if you'd like to support me and other educational creators, the only way to ensure that the money that you spend on Nebula goes to us directly is to sign up directly. So no, Nebula is not going bankrupt. On the contrary, it's more successful than it's ever been, but we're offering lifetime memberships for a select few fans so that we can make even more original content. Huge productions from your favorite creators like new seasons of Jetlag or Patrick Willem's holiday special. And we're in it for the long haul. Lifetime memberships allow us to not take on outside investors. It's the opposite of a going out of business sale. It's a going into bigger business sale. And if you're new here, Nebula includes tons of exclusive videos from me, original series from your favorite people, movies, plays, classes, and more. With your favorites like Johnny Harris, Neo, Jetlag, Real Engineering, Real Life Lore, and LegalEagle, we create the content that other people react to. But like I said, until the end of the month, you can get an exclusive lifetime membership. It's $300 for life. No tricks, no gimmicks. That's it forever. And if that's not your speed, that's completely fine. You can still get a 40% discount on yearly that pencils out to less than $3 per month. And if you want to pay monthly, you have that option too. And now if you want to share the love, you can gift a lifetime subscription to anyone else. So click on the link that's on screen right now or down below to get your lifetime membership or a huge 40% discount. Just click right now before the deal goes away. And after that, click on this link over here for more LegalEagle, or I'll see you in court.